Hey Daniel, welcome back.
It's good to be back.
And how was Montana?
It was my first time up there. It was really, really cool. It's an extension of Colorado almost with more mountains and less people.
Well, I hope you enjoyed the extra mountains and the fewer people. What are we talking about today?
I wanted to talk about estate planning in general. First and foremost, what an estate plan actually is, and then how to give money and assets while reducing, the odds that that inheritance causes a fight or a conflict, and then maybe the best assets to inherit and gift.
Welcome to the Science of Wealth, where we discuss the science behind financial planning and the art of learning and applying it. Okay, so are you planning on passing away or are you expecting to inherit something sometime soon?
Neither. Just good to be proactive, I guess.
Well, there you go. It's the name of the game in financial planning, right? Planning well ahead of the actual crises or emergencies. So good on you. All right. Well, I mean, let's, I guess, start by talking about estate planning. What would you like me to cover here?
Well, I think there's a common misconception that estate planning is just for people that are really well off. I hear a lot of people say, "Oh, I don't have enough money for an estate plan." I know that's not true, and an estate plan isn't really just this multi-generational transfer of wealth. It's also protecting what you currently have. So first and foremost, when we say you need an estate plan, what does that actually entail?
Well, first and foremost, everybody has an estate plan, whether they want it or like it or not, and that's because every state in the United States and pretty much every country, every territory is going to have what are called intestacy laws. Intestacy laws are going to cover what happens when you die without a formal estate plan, like a will or a trust or a combination thereof. So, if you do not make your own estate plan, the state has one for you, and it's going to decide who gets your stuff and how much and so on. So that's sort of just the thing to be aware of for everybody. Not to belabor a Ron Swanson perspective of the world too much, but do you really want some anonymous judge or magistrate deciding who gets your stuff, or do you want to decide who gets your stuff and who gets to handle your affairs and so on? So that's just the baseline understanding here. I think it's also important as we get into this conversation. When we think about estate planning as financial planners, we're thinking about it from a financial outcomes standpoint. We do not get into the nitty gritty of the legal requirements around it, right? We don't know what the exact magic words for a trust to be perfect or a will to be perfect. We leave that to the attorneys. And frankly, we also want to consult with attorneys even when we have a fairly confident idea of what we think a good estate plan looks like. So when we think about estate planning, realistically, what we're thinking about is, what assets do you have, and what is the best and most efficient way for those assets to pass on to the individual or individuals or the charities or the organizations that you want your things to go to in the future. And at its most fundamental level, estate planning is just the organization of documents, beneficiary designations, and so on to effectuate that intention.
Okay, so let me ask, a common objection I hear is, oh, I don't plan on leaving any money to anybody. I'm going to die with essentially zero. Does that person then not need an estate plan?
I mean, the problem with this is your intention to die with zero and your reality may not align perfectly. Now, if your intent is to spend your last dollar and then promptly hurl yourself off a cliff, fair enough, you will have some more control over that. But generally speaking, right, none of us have a perfect idea of when we are going to be passing away or exactly how much wealth we will have, right? When we build a financial plan, we have to make an assumption about a date of death, but it's just an assumption, and we have to make assumptions about the accumulation or deaccumulation of wealth. And so it's the same thing, right? Unless it's a deliberate spend my last dollar, kill myself sort of plan, you are probably going to die with something. And even if you think, oh, I'm going to spend my last dollar, you're still going to have possessions, property, clothing, maybe intellectual property, certain streams of income or insurance benefits. All sorts of stuff can still exist past you. It's not like when you cease to exist or cease to live that your stuff just magically poofs into the ether. So even if you plan to spend your very last dollar, unless you've also cleaned out your house, sold your property, donated every piece of tangible property you have, and so on, there is still an estate. And maybe there's very little in your estate, maybe there's very little substance to it, but there is an estate that does have to be dealt with when you pass away.
Got it. Okay, so what do I have to do? Is it just putting beneficiaries on my accounts and whatnot?
I mean, that's a good place to start, right? If you have bank accounts, you can establish what are called pay on death instructions. If you have brokerage and investment accounts, you can establish what are called transfer on death instructions. If you own accounts jointly, for example, joint tenants with rights of survivorship, then survivorship kicks in and that's going to be taken care of. So a lot of your assets can kind of pass to beneficiaries by what's just called process of law. And in process of law, essentially, you've already made your instructions known. Now, there's good and bad things there. The good thing is if you have your pay on death or your transfer on death and so on established, then stuff's going to pass on, and that's just going to happen essentially automatically, plus or minus a little bit of paperwork after you pass away. The downside is that stuff can supersede your later established wills or trusts. There's sort of a famous case in the last year or two where a man was dating some gal in the 80s and made her the beneficiary of his 401k, and then they broke up, and later he got married and had kids and all of this, and never updated his 401k beneficiary designation, and died in 2024, and his ex-girlfriend got $1 million plus 401k. So pros and cons, right? Like all things, it's only as good as it is accurate. So it's a good place to start, but then you still have an obligation to keep up on it. And then the problem with all these beneficiary designations is that that's not going to handle your more tangible properties like your home, your vehicles, your personal possessions, and so on. So then there's still need for wills and or trusts to handle those things.
Such a good point about the beneficiary designations. So just to clarify there, do beneficiary designations on these accounts supersede anything you may have written in your will that is contrary to the designations?
This seems to be sort of a state by state problem, but generally, from my observations, just in understanding precedent in a lot of places, the answer to that is probably yeah. It typically does supersede. Um, I think you have a fair case, right? Like if you're the wife and the children of the person from the example, you are almost certainly going to go to court and you're going to sue and try to make a change and whatnot. But I know in that particular case, they lost. The ex girlfriend got to keep the 401k. So there's definitely a problem with it in that state by state, you may have statutes in place that make it easier or harder to override those instructions. And so I think there's nothing better than just reviewing that every single year and making sure everything is current.
Okay, that makes a ton of sense. But where does an attorney come into play here? Is this specifically for items like property? Because things like beneficiary designations we can do on our own or help facilitate with a client.
I mean, it's for property, but there's what we often like to call an estate package, not just a will, not just a trust, but a will and or trusts, things like special trusts or designations for caring for pets, or for dealing with minor children, things like healthcare directives, durable powers of attorney for if you become incapacitated. There's all sorts of kind of complex stuff that comes into it. And my basic premise on this, a lot of people like to go to websites for their estate documents. They like to just go to a trust and will or an estate.com or a wealth.com or something like that and pay $200, $300 and fill out some questions on a questionnaire. And poof, I've got some legal documents. And as long as I get them signed and notarized, whatever else I need to do based on my state, I'm good to go. My only problem with that realistically is just like, when was the last time you, random Joe citizen, took a estate planning class or an estate or elder law class? Like, do you actually know what your will or your trust and all that is actually doing? Do you know that you've checked the right boxes or the wrong boxes? Do you understand really what you're doing here, or are you just sort of answering the questions to your best of your ability? Unfortunately, a lot of legal stuff is sort of impermeable. It's written by lawyers for lawyers, and I think estate plans have a lot of that. And so I think it's often a thing where if you are 21 years old, fresh out of college, you've got a car, some clothes, and like $100 to your name. Sure, the online thing is probably going to be reasonably adequate for your needs and your circumstances. But I think as your life gets more complicated, whether that be you have a business that you own, whether that be getting married, having children, having family members who are financially dependent on you, all these various things that can occur, I think the necessity and the importance of an attorney exponentially increases very rapidly. Where I think realistically, if your very first estate document is like a DIY online thing, that's fine. But by the time your situation gets complicated enough to want to have a second, if you're not working with an attorney, you are being penny wise and pound foolish.
Got it. So estate planning is one of those low urgency, high importance items. You mentioned, say, a 21-year-old with maybe a car and some clothes and property, or maybe no property, just the car. Would you urge them to get an estate plan in place, even if it is a trust and will or something you can do online? Or is there a specific time in life where this becomes significantly more of a priority?
Well, I mean, let's actually take you as an example here, Daniel. So, are you married?
No,
Not yet, anyway.
correct.
Have any children that you know of?
I do not believe so.
Okay, great. If you drop dead right now, what's going to happen to your stuff?
I have beneficiary designations on, qualified accounts and taxable accounts. Other than that, it's really just a car. And to be honest with you, at present, I don't know exactly where that goes.
Great. So, do you think it is reasonable or, perhaps prudent to have a better understanding of where your stuff is going to go?
Yes.
And is it fair to say that you are not fully aware of the Colorado statutes that govern who would receive your car or a portion thereof, or who would receive your clothing, your personal possessions, and so on?
That is not something I am fully knowledgeable on.
And do you know who in your family or who in general would be responsible for administering your estate?
Nope.
Okay. So is it reasonable to say that you, Daniel Stefanski, or somebody like you probably need an estate plan or would probably prefer to have an estate plan than having a bunch of unknowns like that?
It would seem wise after this discussion.
No. And that's sort of the base point here. Even if you are the 21-year-old straight out of college, you don't know, right? I mean, unless you were a pre-law student or you're going to law school, chances are you have no idea what your state intestacy laws are or what the statutes say about who's going to get what and how much, so on and so forth. And imagine you have a more complicated situation. Maybe you have a long-term romantic partner that you were planning to propose to any day now, and you would want to take care of them. Imagine it turns out that, through reckless happenstance or, living it up in college, that you do actually have a child that you're just not aware of. Imagine that you and your brother had a falling out 2 months ago, and now you wouldn't want him to get anything, or you're estranged from your father in all but legal terms. Like, there's all these various complex things that can go on in anybody's life, and if we have not taken the time to designate who and what is supposed to happen and how things are supposed to go when we pass away, we're leaving it up to the state. When we're leaving it up to our family members to potentially fight, squabble, or otherwise bicker over it. We're leaving behind problems for our family to deal with because we thought to ourselves, well, my situation's somewhat simple, somewhat straightforward. So again, you asked sort of the question, right, when does it get complicated enough? I argue it's complicated enough to begin with. It's just a question of prudence, right? Should I spend, $5,000 on an estate package when I'm 21 and just got my first job paying $50,000 a year? Probably not. Right. But again, I think as soon as it becomes financially viable, or as soon as your situation is knowably more complex than what you might think of as the most basic default situation, it behooves you to engage that counsel and have a real conversation about it.
All right. I think I'm taking the rest of the day off. Got to get my affairs in order.
Hey, as long as you plan on living a long and happy life like the rest of us, hopefully it's not too urgent.
So, us as planners, right, we can't draft these documents. We can review them with clients, but exactly what is our role if we're not the ones drafting them for folks here?
I think first and foremost, it's very similar to tax planning in that, there are estate attorneys who absolutely are just kind of in the business of producing documents without planning. Planning, kind of estate planning, is a separate thing than just the drafting of documents, in the same way that tax preparation is a different thing than tax planning. And, if you pay it's sort of a Hearn's Law thing, you'll pay for what you get, and if you're lucky, you'll get what you pay for. I think a lot of people engage attorneys or tax preparers or, professionals of any sort of stripe to just sort of do the thing, but not necessarily paying enough to get the really advice or planning around it. So estate planning from a financial planner's perspective, again, we're not attorneys. We're not going to draft these documents, or at least most of us are not attorneys. And if we are attorneys, that would technically be an outside business activity separate of our practice of financial planning. But, in the case where we do kind of estate planning, our first thing is just checklist, right? Hey, do you have those beneficiary designations? Do you have the transfer on death, pay on death, IRA, Roth, beneficiary stuff established? Great. If you do have that all established and taken care of, from that standpoint, Have we then gotten documents, wills, trusts, durable powers of attorney? So a lot of it's just like, do you have something in general? And if not, stop, do not pass go. Here's a referral to an estate attorney. Here's a list of DIY platforms if that's more prudent in your particular case from your perspective, or you just don't want to spend the money on a full estate package. But ultimately, just do we have something in place? Number one. And then there's a really, really, really big gap in estate planning past that point where, assuming the checklist is satisfied, it's sort of all in the domain of attorneys, right? Just, hey, if you have a question about modifying your agreements or your trust or your whatever it is, you just need to talk to legal counsel. And we're just here to sort of keep you up to date and honest on that and kind of remind you that you should be paying attention to and working on this. It's only when we then either in certain states, that have low estate tax exemptions, or in a state like Colorado where there is no estate tax exemption that differs from the federal exemption, that we suddenly step in and say, okay, now we are either on a life trajectory to exceed the estate exemptions, or maybe you are or you aren't, but you would like to do more charitable gifting or more philanthropic work during your lifetime and would like that to flow through into your estate and your legacy. And so then it becomes kind of jumping over the big gap between just, do you have the fundamentals in place, to a lot more advanced stuff like intentionally defective grantor trusts or charitable remainder trusts or qualified personal residence trusts. There's a whole like alphabet soup of CRT, NICRUT, QPERT type language that just has to do with essentially really advanced ways to reduce taxes or protect and shelter assets. And there's reasons you might want to do some of this asset protection stuff well before the estate tax issues, just for creditor or bankruptcy reasons. But functionally, it's going to be these more kind of high level advanced planning items where we're really trying to kind of protect assets either from taxation or from third parties for whatever reason, or sometimes we're just trying to protect it internally. Maybe we're a blended family where, I'm on my second marriage or you're on your second marriage, or there's kids from a prior relationship. And we're trying to make sure that our second wife, second husband, whatever it is, doesn't kind of screw over the children of our first marriage and so on. There's a lot of stuff like that where, again, there's a big delta between initial documents and then really just kind of case by case advanced planning items.
I think you made a really good point there about the similarities between uh, people that pay for tax prep and think they're getting tax planning, and maybe some folks that just get estate document preparation but think they're getting proactive estate planning. So it sounds like we kind of help bridge the gap between the actual preparation of documents and the long-term strategy of where we want to go with what we currently have.
Well, and there's a really good element here where the phrase solely incidental is sort of helpful. So, for example, as financial planners, the vast majority of us are securities licensed, and so we are going to give, more than solely incidental investment advice. But folks like accountants or lawyers are going to be involved in solely incidental investment advice all the time. They're saying like, hey, as a lawyer, I'm just going to recommend, for this particular type of trust or asset or whatever it is, you should be, more careful with your investments, or you can be more aggressive, or there's going to be a lot of taxes due with this type of trust, so you want to use really tax efficient strategies. And they're not going to probably get into like the pick this stock, pick this bond, pick this fund sort of stuff, but they tend to lean into that. We sort of have the same relationship when it comes to estate planning items or tax preparation items, in which we say, look, we're doing estate planning, we're doing tax planning, we're recommending that this type of trust based on our calculations would be beneficial, but you're the lawyer, you're responsible for implementing it. Or, hey, we're recommending these tax strategies, but you're the tax preparer, you have to make sure that that's documented compliantly and correctly so that they actually get the benefits of it. And I think that it's a complementary relationship. Every once in a while, you do see some estate attorneys kind of throw their elbows out and try to point at planners and say this is unauthorized practice of law. But there's a really bright line test on unauthorized practice of law when it comes to estate planning, which is we are not fundamentally making the final recommendation for you do need a will, you do need a trust, you need this specific trust, etc. We are either recognizing the absence of basic items, again, that you have a will, that you have a trust, powers of attorney, whatever the case is, and recommending that you work with your attorney to get those in place, or we are running a tax analysis, running an estate analysis, and saying, okay, based on our understanding of these trusts or these estate mechanisms, these are the most beneficial vehicles, most likely from just a purely financial standpoint, to accomplish or effectuate your goals. We now need to work with an attorney and get their professional advice and insight on how effective that's going to be in a state like Colorado for your particular needs to determine whether that is the correct thing. So it's largely kind of planning, forecasting, and educational. At the end of the day, we are not drafting the will or the trust any more than we are filing the taxes.
Makes sense to me. I'd say the last question I have here is, this isn't a specific document or a designation, but would you recommend, creating, a Google Doc or some sort of document that says, hey, loved one, um, if and when I pass, review this document. It's got my passwords for accounts, it's got people to reach out to for specific investments, or, instructions on what to do if and when. Do you see, validity in creating a document like that, regardless of any designations or state documents that you put in place?
Most wills or trust documents that I see have a sort of like appendix in the back where it says like, hey, wait, please list all your accounts, your assets, et cetera. It's there to help your personal representative or your executor figure out where all your stuff is. I've never seen more blank pages. I really hate to say it, but for whatever reason, people just don't seem to do that portion very well or very effectively. That is something where, if you work with a financial planner, I think a really great thing you can do there is just say, hey, I work with this financial planner and they know where everything is. So talk to them in the event of my death. And then hopefully you're still working with that planner 10, 20, 30, 40, 50 years, in the future when you pass on and those documents become relevant. But this becomes part of that annual review process. Hey, when was the last time you updated your list of accounts? When was the last time you made a list of your usernames and passwords? You got to be really careful with that. Like you mentioned, a Google Doc. Absolutely not a Google Doc. Like under no circumstances should you ever on any online platform be typing in all your usernames and passwords and like just saving them in a file somewhere, because you are all but guaranteeing that at some point unknown in the future somebody's going to steal that or get access to that, and then that's a big problem. You find occasionally that there are these kind of cutesy books or like binders that say like, in the event of my death, read me. Like they're kind of funny looking, but we're all trying to laugh about a serious thing here. And those will often have like a form that says like please list all your accounts and all your usernames and passwords, account numbers, etc. And then the idea is that it's on paper and it's in your house. There's an obvious problem here as well, which is if that's just sitting on your bookshelf, then anybody can walk by and take that book off your shelf and get your stuff. So I see a lot of stuff where people, if they do draft something like that, it'll be like a Word document that they didn't save. They'll print it out, they'll put a copy with their trust, put it in a safe, or they'll give a copy to the executor or something like that, and put it like in a sealed envelope. There's no perfect answer here, but I will say I find a lot of people find themselves when their relatives pass away, checking the mail for the next year, looking for like quarterly statements to come in or something to tell them that there's a timeshare somewhere or a insurance policy somewhere or a bill that needs to get paid. And it's unfortunate, but it's kind of just a hard reality to avoid in practical terms.
Yeah, we see it a ton. Someone's loved one passes, and more often than not, the process is not seamless. There's accounts they don't have access to or have no understanding of how to obtain information on, and it already makes what's an emotionally draining experience that much worse. And I think the easier you can make it for everybody else in the process, even when you're not here anymore, is pretty big.
Yeah, and I think that functionally can just be the thing that makes a tough experience just a little bit easier. Is just trying to make it easy on that person. And again, it's not fun. It's not pleasant. We're all going to live forever until we don't. And anybody listening to this, good news, you're still alive, and hopefully that's going to continue for the foreseeable future. But also it sneaks up on you. I think about even like I got married just a little under 2 years ago, and within essentially a month of the wedding, one of the guests had died, younger than 30, motorcycle accident. My officiant passed away about 9 months later, not even 9 months, 7 months later. So, I mean, it'll sneak up on you, right? Again, we're all alive until we're not. And so it is just something to be mindful of that when we say, you said earlier, it's a high importance, low urgency item, it's always going to be low urgency until it's not. And the problem is you don't decide when that happens.
So, talking about making the unpleasant a little bit more pleasant, how to give money to the next generation or loved ones while also minimizing conflict. In a personal experience, I've seen some folks inherit money in equal and greater and lesser sums than others. And either way, I've seen both create massive conflicts between those parties, and probably conflicts that the person who gave the money to them when they passed didn't foresee or really wouldn't love to see if they still were alive. So, what could they have done differently, or what can people listening to this maybe do to hopefully reduce conflict between their loved ones if and when they inherit things?
I think specificity and communication are your greatest friends here. I say specificity because the more generalized things are, the more it is subject to interpretation. Interpretation then is subject to self interest and conflicts of interest, more so than specific direction. And so those conflicts of interest and interpretive problems can then breed that conflict. Whereas if you say like, look, everybody gets this exact thing, this exact amount, this exact percentage, then you're reducing that potential conflict. I think also communication before the fact. I think a lot of conflict in estates is driven by failures to communicate in advance. We've touched a lot in this podcast over many episodes about long-term care planning, right? You're planning for yourself, planning for your parents, and so on, and the importance of getting a better understanding of your parents' situation or sharing with your children your situation more and sooner than later, rather than waiting until the last possible second or never having the conversation. And I think being just clear about your expectations and answering questions. I say all of that, advisedly, recognizing that many people do have children or relatives or family members who are not going to cooperate, right, for any number of reasons, right? They are the selfish child, they are the black sheep of the family, they are kind of disowned or uninvolved from your family. Whole variety of reasons or things that can occur here, but functionally the biggest things you can do is be specific and communicate in advance. And the big thing around that as well then is when we're thinking about the nature of assets, everything in your power that you can do to separate things from the get-go so that there's less kind of consensus required regarding the distribution or the use of assets, I think is also very helpful.
It seems to be a pretty common theme in our podcast episodes here is talk to the next generation and have an open and clear dialogue and communication within reason as much as you can. Seems like that's going to be the case here too.
Yeah, and I mean, that again is going to help reduce conflict in the first place, but also it helps get some things out in the air. I think there's a lot of personal experience and cultural significance to a question of equitable versus equal when it comes to inheritance and leaving things behind, right? Some people are very firm. You just, if you have two children, you go 50-50. You have three children, you go one third, one third, one third, and so on. Some people will say, look, I want to make sure the things I leave behind have the biggest impact on the right people and, have less of an impact on others. And that could lead to some sore feelings, right? Imagine you have one child who gets into a lot of trouble, is in gangs, drug abusing, or whatever the case is, who maybe they've gotten their life back on track by the time you pass away, but your other child is a accomplished doctor, and then you decide, well, the accomplished doctor is going to be okay, so I'm going to leave more to my child who had trouble in life because it's going to make a bigger impact on them. Your intentions are good, but if you don't explain your rationale and communicate well with both parties about how and why that's going to be the case, I guarantee you're going to cause some harm to their relationship when the doctor who's done all the right things in their life, opens up the will or, is getting their thing and they find out they're receiving 10% and their drug addict, sibling is getting 90%. So it's something where whether you go equitable or equal, again, you want to just be very clear about your reasons for that and explaining that to each party. And again, you want to keep that current. I think another problem that I see in estate plans quite often is that there is an equal or an equitable intention. When they did their will in 2005, right, when one of the kids was still in college and they're helping pay for the college, and one of the kids was grown up and out on their own, and so they changed up the balance of stuff. Maybe it was 60-40 instead of 50-50, and then we're 20 years on and it still says 60-40, and maybe the dynamic has changed substantially. So back to at the same time that we're reviewing, do we have all the beneficiaries current on our 401k, our IRA, our bank accounts, our brokerage accounts, and so on? Same thing for the will, right? Does it have an equitable or an equal distribution of assets? And when I think about that today, is that the distribution of assets for my family?
And I think a piece of this too is, sometimes folks may not even know if they're going an equitable route or an equal route because certain assets and things that they give to the next generation may have different implications from a tax perspective or a timing of sale. Can we talk about maybe the best and worst assets you can give people and give, to donations and charity and organizations.
Sure. I'll actually even use a really good family example here. So, my grandparents on my father's side passed away when I was younger than 10, I think, or just over 10 by the time my grandfather passed away. And they left assets, I think, largely equally to their three children. So, my father, my uncle, my aunt. And that included the primary family residence. Right there, nice house, sort of in the middle of Napa, California. Really nice property, pool, wine country, a lot to like there. In doing that, they made the decision that the executor, who was my aunt, was also going to get to live in the home because she was already living in the home when my second grandparent passed away. And that's a case where the property is one third, one third, one third across the three of them, but that has produced an enormously inequitable division, not because it was unequal, but because the aunt has essentially effectively occupied that property now for over 25 years, and has sort of over that time been more or less able to support herself and pay the taxes and do the upkeep on the property, such that my father, my uncle, as equal owners of that property, have had to step in multiple times to help pay taxes, to pay for upkeep and maintenance, to service the property, and keep my aunt from being homeless in that situation. And it's something where ostensibly, right, when you think about leaving something like a primary residence to the family, you think, well, if I leave it equally to all of them, then if they sell it, they'll all get an equal share, and we're all done and dusted and good. That's a really good example of a thing where emotional significance can heavily outweigh the practical economic factors or numeric factors of what assets do or don't get left behind, right? It could have been the case in something like my grandparents' estate that leaving the house free and clear to my aunt and leaving more cash, retirement, whatever else to my father and uncle might have been a better, more equitable, and more equal division of assets. Where instead of tying them together through this joint asset, there could have been a much easier division. So I use that as an example to head up your question here, because when we think about what are the best or the worst assets to get or leave or receive, there's a numeric answer here. We can talk about net of tax ramifications and so on, but there's also a very important kind of just qualitative element here related to the personalities and the emotional attachment people may or may not have to certain parts of their inheritance.
Yeah, that's a part I didn't even really think about, is the fact that it's not just, all numbers as I might think it is as a financial planner. There's also an emotional aspect to a lot of the things that are left behind. And I think the example you used is a really good way to kind of visualize that. Um, how do you take that into consideration? Is that something we facilitate, maybe conversations with clients as opposed to an estate attorney or somebody else? Or are both of us taking place in parsing out maybe the emotional complexity of some of these transfers of wealth?
Well, and what's a good asset to receive or what's a good asset to leave behind is going to differ by the perspective of the person leaving it behind versus the person receiving it. So I think those emotional conversations, family dynamic conversations, happen with us. I think they happen with legal counsel, right? In a perfect world, they happen with all parties involved, right? Not just the grantor, but also the recipient of inheritance, where we're having the big family meeting and legal is there and we're there and so on. I think that's sort of the best way to try to overcome some of those hurdles in advance to kind of get those conversations, those frictions out in the air to begin with. I think then when you start getting into the question of what is best or worst to receive, then there are quantitative factors, assuming that all the emotional factors are removed, but how much you apply a premium or discount really heavily depends on those family dynamics.
And like you said, that's going to differ from family to family. So we can't really speak on objective facts here, but let's talk about the quantitative part of it. Are there assets that are better to inherit than others simply from a net dollar perspective?
Yeah, I mean, right out of the gate, if I have to just remove emotional components from it, and if we're ignoring estate tax ramifications, because that's going to complicate this a lot, I think your best inherited dollar comes in the form of a Roth IRA or Roth 401k. It's highly liquid securities. Or just cash. Whether it's securities or cash doesn't really matter. But the reason that's going to be preferable is because we have the best possible tax treatment, right? We are going to be forced to take it out of the Roth, but at least for the foreseeable future, for at least the next couple of years, we're probably going to get the best tax treatment in the tax code, right? The ability to invest, grow, compound tax free. And then, we have highly liquid assets, again, stocks, bonds, ETFs, mutual funds, preferably with low costs or little to nothing in the form of transactional costs, where at the end of the day, we can kind of get our money out wholesale. From a recipient standpoint, best dollars we could possibly receive. Now, these can become comparable then to receiving taxable assets. Because as many astute listeners would point out, you can get a cost basis step up at death in taxable assets. So you owned stocks, ETFs, mutual funds in a brokerage account, or you had rental properties or primary residence or business assets. And maybe the basis on those was very low. Maybe you bought Amazon back in the 90s and you've been holding on to it and it has a basis of $500 and it's worth 200 grand now. Well, good news. We're getting a huge step up in basis. The reason that these are less preferable than the Roth on the securities side is going to be because they are still going to throw off taxable income in the form of interest, dividends, or that sort of thing. And, or, we get a step up to the date of death, but maybe it takes a month, 2 months, 3 months, 6 months, a year to actually get our hands on this account due to any variety of estate things. And so now, even though the basis has been stepped up, we still have this floating potential tax ramification that's just adding to the complexity of the estate, adding to the complexity of our own taxes when we receive it, and maybe we have some capital gains issues to deal with upon receipt. The tax advantages are there for the same thing for like the rental properties, primary residence, but these are less ideal than just liquid cash securities in a brokerage account, because not only do we inherit this big tangible asset, we now inherit its costs. So property tax, we inherit its insurance costs, we inherit any outstanding mortgage or liabilities or loans on it, and we also inherit the liquidation transaction costs, right? So we inherit the family home. I look at my brother, I look at my sister. None of us want to keep the family home. We say, well, great, we'll just, one third, we'll just sell it. Well, that's fine. We sell this property for $500,000. We're still going to probably have, 6% ish in real estate closing costs. And now we did not inherit $500,000. We inherited $500,000 minus the closing costs. Not to mention the property taxes, insurance, and everything else we had to pay on it while it was still there. So less ideal in that particular situation. And also, again, because it's a big lumpy asset, it's hard to divide up, because maybe one of us wanted to keep it and some of us didn't. And now there's a whole thing about like, well, maybe you keep the house and you can live in it or rent it out or whatever, and we'll take more stocks, bonds, whatever from somewhere else. And then we got to figure out how much capital is available for that purpose. I think the least advantageous thing to inherit is just going to be pre-tax retirement assets. We get the tax advantages of that. Most people today inheriting that are going to get a 10-year rule for distributions in almost all cases, meaning that we need to take out essentially a minimum distribution every year for the first 9 years. And then in the 10th year, we're going to have to push all of it out. There's some certain situations where, depending on whether it was the first person to die or the second person to die, whether we may run into a situation where we have to take out more distributions or do it faster or something like that, but that's sort of the basic guideline. And basically, it's just sort of the worst version of things to inherit, because we're going to have to pay taxes on every single dollar of it.
Sounds complicated.
Yeah, well, and that's the whole thing here. Much like the tax planning, much like the estate planning itself and so on, most of us are only going to die once, right? Most of us are only going to deal with an inheritance a handful of times in our life, if any. And so it's something where if it's not your full-time job to work in estate work, right, or it's not a good portion of your work like it is for us as financial planners to do estate planning, it does really help to engage legal counsel, financial planning help, tax help, and so on, to get it right in the planning phase and to make it as easy on yourself as possible on the distribution and outcomes phase.
I think that's a good way to cap it off. I think that's enough estate and death talk for the day.
I mean, hopefully, and again, we're all going to live forever until we don't. So from that particular standpoint, try to enjoy the time that we have. Just make sure you don't leave a big mess for your family. But I think on that note, then we'll go ahead and transition to our favorite question every week, as always. Daniel, what have you learned since you were last in the podcast that you'd like to share with our audience?
It actually has nothing to do with our conversation from today, but I was in Montana last week, and it, funny enough, came up more than once with more than one different person. And it's something we've talked about before and something I find myself continuing to repeat. It's the conversation around compensation. everybody focuses on one part of compensation, and that's salary. And I completely understand that salary is very important, probably the largest part of that compensation. However, it's oftentimes one of the most rigid as well, right? There are tables and, ranges and bands for salary that really just aren't going to be moved too much one way or another. However, what people continue to fail to take into consideration are ancillary aspects of compensation. Even things as small as the difference between paid time off, whether it's a unlimited or it's a certain amount per year. Does that get paid out at the end of the year, or do you have to use it or lose it? Do you have a commute to work? If so, is one considerably longer than another, and will you end up spending considerably more time away from your home and loved ones doing that commute and spending more money traveling? It's things like health insurance. It's items like continuing education. Will they pay for those? And at the end of the day, while salary is an important metric to use and review, overall compensation is considerably more important. There are so many stories out there of someone saying, "Oh, I make $100,000 a year right now. I just took a job paying 120 salary, but they don't offer a 401k match. I don't have a good health insurance plan, and I commute considerably longer to work, and I actually don't like the people nearly as much." And overall, I would have rather go back to the $100,000 job. I felt like I was making more and I enjoyed it more. Uh, there's so much more than salary, and just asking what the salary is not nearly going to move the needle as much as some of these ancillary ways to get compensated will when you factor them into the decision.
Yeah, I mean, you said a lot there, but I can't begin to stress the importance of not only just benefits, right, the health insurance, 401k, et cetera, but the ancillary stuff, right, the commute, enjoying your work, enjoying the people you work with, and so on. I'm actually presenting on this at the XYPN Live conference next week in Austin, or as the time of posting this week. But it's fascinating. I spend so much of my time having this conversation, not just with clients, but even colleagues. And everybody, as you said, focuses on salary, focuses on gross compensation there, and really fails to take into account all the qualitative factors and the semi-qualitative, quantitative factors like the benefits. I mean, easy way to put a value on it. No benefits, call it a 0% premium. Full stack benefits, but everything you could possibly ask for. 30%, 40%, 50%. Really try to apply that discount rate. I cannot stress it enough. I think it's a huge mistake that people make all the time to just say, who's offering me the most money? That's all that matters.
Great. Thanks, Dan.
The Science of Wealth is produced by My Wealth Planners, a registered investment advisor in Colorado. The theme song is This Is Your Time by Dan Phillips. The podcast is intended for educational purposes only and is not investment advice or any other form of advice. Not all material discussed on the podcast is appropriate for every individual in every circumstance, so you should consult with a certified financial planner, tax professional, or legal professional as appropriate before attempting to apply any of the subjects, strategies, or tactics discussed on the podcast.